Let's go to it. Terri, we got one here that I think is interesting. Can a co-defendant defense lawyer approach another co-defendant without their lawyer present? This comes from Rosie Gar 49 from Twitter. So can a co-defendant lawyer approach another co-defendant without that lawyer present?
No, you're gonna have to go through the attorneys. I mean, normally you have the prosecution and the defense, and it's one lawyer for the prosecution, one lawyer for the defense, and clearly they have contradicting and, interest in mind. But here, even though some of the co-defendants may have some of the same theories about the case, they may have some of the same defenses about the case, they still have individual representation, and you need to go through the attorney before you have a conversation, because there is the possibility that there could be a conflict there. So for instance, one co-defendant may want to point the finger at another co-defendant, and so if the attorney for one speaks to the attorney for the other, they need to have representation so that their interests are always protected. Good question, though.
Yeah, that is like an absolute in the world of lawyering. Anybody who is speaking to a represented client is going to wind up having an ethics charge filed against them. And of course, the consequences could be pretty dramatic, and prosecutors won't be all too happy about that as well, because it creates an appellate issue for them, not of their own making. It's bad enough when you create your own appellate issue, but not when there's an issue with regard to that. All right, a defense. Let's work on this a little bit. I think this actually has a lot of depth to this, right? So a defense lawyer's responsibility, sacrosanct, is towards that particular client. And when you're dealing with a case such as this, one of the reasons why each person has to have separate lawyers is because there could be a conflict of interest. Even a lawyer who learns some information from a client, this happens all the time, learns some information from a client, and that client doesn't hire them, but then another co-defendant may want to hire them. Many times, Terri, they're going to be precluded from being able to take that case because they had gained attorney-client privileges from the co-defendant that they did not represent. That's how strong that is.
It is very strong. In fact, it came up in this case for Brian Steele. He is one of the attorneys actually for Young Thug, and he represented other defendants in similar types of cases, and the prosecution was actually trying to get him off of the case. I'm not sure if the co-defendant attorneys were trying to get him off the case, but that issue comes up because you are going to get privileged information from your client, and that information cannot be shared in any way, shape, or form. So it does make sense that if you represented one co-defendant, you would be very difficult representing another co-defendant in the same case.
Yeah, I mean, where's, and this is another problem, again, just in real world, in real lawyer world, what can happen under those circumstances is that information, what happens if you have information from the person that you do not represent that may be exculpatory, right? Like, in other words, may help out another co-defendant, but be inculpatory or hurt the original person you spoke to. Where's the defense lawyer's allegiance? To the first person they spoke to or to the second person they spoke to?
I've got to tell you, Bob, if that happened in real life, and if the attorney took that information and helped his second client versus the first client, he could be disbarred for that. There would definitely be some violations there of attorney-client privilege.
You know what we got to do here, Terri? We got to bring in Paul Townsend.
Oh,
Paul
yes.
Townsend, criminal defense lawyer. My man, Paul, how you doing, buddy?
Hey, Bob, good to see you.
Now, I got to ask you, I've seen it happen. I've seen defense lawyers that, in the real world, your phones are ringing in your office. That's why we have a very significant conflict checked in our office where there's co-defendants in a case. And if they consult with you and they give you information and you decide maybe they can't make the fee, or you decide you're not going to represent them, or they decide to go to another attorney, and then another co-defendant in that case comes in, and you've now had confidences from two, separate people on the same case, there is a way to maybe get around it, but it's something that needs to be done with judicial approval, notice, and waiver of those clients. But talk to us about how lawyers fall into that trap and can find themselves in a very difficult situation.
It's very true. You can get into a lot of trouble doing this. And even in New York City, which, most people realize is a sprawling metropolis, the universe of criminal defense attorneys is not really that big. So this is a situation that happens from time to time where you'll meet with somebody, you'll speak to them, you'll try and figure out, am I the right lawyer for you? Should I be representing? You discuss the facts of the case, you get a sense of what's going on, where you are, have motions been filed, and then for whatever reason, they don't retain you. And now you have this information in your bank and you're thinking about it, and a co-defendant calls you and says, you're my guy, you've been recommended to me, you're so good, I really want to hire you. It's not a blanket, I can't do it, but like you said, the three things: you got to get notice, waiver, and approval, and you really have to be so upfront with everybody from the very beginning about your previous conversations. You've met with them, you've had access to material non-public information, and for you to take on the representation of that co-defendant, everybody has to be in agreement that this is okay. And if the prior potential client who came to your office says, I'm not comfortable with that, I told you things that could come back and bite me, then that's it. Then that's it. You can't do it. As you and Terri have both said, it opens the door to egregious ethics violations, and no attorney wants to get that reputational hit of somebody who is willing to have those conversations in confidence, in private, those sacred attorney-client conversations, and then turn around and use them to that person's detriment later. It's just a bad look overall.
Yeah, and I'll tell our lawyers that are out there that watch us, are our lawyers to be, because I know there are so many that look at the advice that you guys give. You may not even realize it's a conflict at the time that you do it, and then later something develops during the course of the trial, and you're like, oh my gosh, something the other guy said is relevant to my client's defense. You just don't want to be in that position. So most lawyers, I think good practicing lawyers, are like, look, even if I don't really perceive a conflict now, I'm not going to get involved in what potentially could be a conflict down the road. All right, guys, listen, Just Chillin' here from Twitter asked the following question. Why is the state allowed to use the song Really Be Slime as evidence and say that Young Thug is rapping those lyrics when it's actually YNW Melly and Young Thug isn't even on that song? And why didn't Brian Steele bring that up during opening statements? I don't know if they know this or not. Terri, you know everything about this case. Is that making sense to you?
Well, listen, what I can tell you is Judge Glanville decided in the very beginning of this case that lyrics can be used against these defendants. So there are 17 songs that are allowed in, and the judge has stated that you have to lay the foundation, you have to set the relevance of each of these lyrics before they come in. But he ruled, look, for these we are going to consider as we go along throughout the trial. The YNW Melly case, just the opposite occurred. The judge did not allow lyrics to come in. And as a matter of fact, the prosecution said that she wasn't going after the, defendant here because that wasn't part of the case. She admitted that the lyrics to his case and his song had nothing to do with what he was being charged with, the murder of, two of his, collaborators that he was with. So I don't know this particular song that our viewer is bringing up, but what I can imagine is it doesn't matter who's really singing it. If the judge has said, look, I think there's some relevance here, we'll make a determination at trial whether YNW Melly is singing it and he references Young Thug, or whether Young Thug is singing it and he references YNW Melly. The judge decided that some of these songs, some of these lyrics can come in, and the prosecution has to make sure that they've connected it to relevance.
Well, Terri, I used to engage in the impossible because there were times where I had, and I'm surprised more criminal defense lawyers were not in the civil rights world. But to Paul's point, it is a very complex area of law because you have federal civil rights violations, you have state violations, you have violations for malicious prosecution, false arrest, and on top of it, there's different filing requirements from state law versus federal law. I used to love it because it was really complex, right? But in the end analysis, in federal law, for example, for a federal civil rights violation, you have to show a custom, practice, or policy of deliberate indifference. It comes from the name of a case, Monell. And to Paul's point, while it doesn't require necessarily that you knew, it requires pretty much that you were aware that your customs practices and policies were deliberately indifferent. And then this is where the big argument has occurred over and over again. We especially heard it during the George Floyd time period and during those kinds of cases. A lot of states also impose immunities, okay, which basically say, if the officer or the entity or the government officials were acting objectively reasonable, even if they were completely wrong, we're not going to allow them to be sued. So let's get into the politics of it, right? Because I used to go crazy when nobody would really discuss it. I was a government official. I handled tens of thousands of cases as the head of an agency. And I believe our people did things honorably, honestly, ethically, with integrity. We cared about getting it right. We cared about using the system to assist people get better from addiction and mental illness and things like that. And we also are proud of those people that we put away for as long as humanly possible because they represented continuing danger. But it's a human institution and people make mistakes. What that immunity is supposed to be doing there is that even if you can get past all those hurdles, is to say, you will chill people like Bob Bianchi or people that work for Bob Bianchi from wanting to be in that environment if every single innocent mistake that they make can be a civil rights case against them. What are your thoughts about all this?
Well, you raised some excellent points, Bob, as always. I look at this in two different ways. One, on the civil trial, or two, on the federal level. The state is going to bring, charges against someone. And if those charges are, defeated and the defendant wins the case, you might think, as our viewer has asked, that you can bring a malicious prosecution claim against the prosecutor. But to your point, there's protection in place. If the prosecutor is making a decision, they had probable cause to go ahead and bring that indictment against the individual, and whether or not, they acted in good faith, it is very difficult to bring a malicious prosecution charge against someone who is acting within their duties on the state level. I do think that on the federal level, when we're talking about civil rights, when we're talking about due process, or even the pattern in practice, I think those are a little bit easier for the prosecution to prove than on the state level for a malicious prosecution. And I say this because I believe that when someone's rights, their civil rights, their due process, equal rights, when that has been violated, the federal government can actually use evidence that goes beyond like what actually happened at that crime scene. So I do think that if you wanted to bring a charge and you wanted to say, look, my due process was violated here, I would do that over doing a malicious prosecution. But let me just end by saying this. Both of those are very difficult to prove. I mean, we've seen it in the past. You talked about George Floyd. We've seen some successes in some of the cases that we've been covering, but it's still very difficult to prevail.
All right, Terry, let me bounce it back to you because you kind of said this before. One of those things that I think you were talking about, criminal civil rights violations, which are different from civil rights violations. Maybe a better area to go, but in those cases, in the criminal one, they're allowed to bring in a lot of conduct that otherwise may be inadmissible in a normal trial. Just like RICO can bring in a lot of conduct and connect people who may not have known that a murder was going to be committed, may not have wanted a murder to be committed, but if you are part of the enterprise and the crime occurs, you can be held accountable. And the reason I ask this is that Slyte from YouTube asked this question: is this RICO dangerous for our democracy?
Well, it's an excellent question. I mean, it could be, as any law could be, if it's abused. I think if it is used as it is intended, it's not dangerous for the democracy. And if a prosecutor believes that there is criminal activity, that there is an enterprise, and that they are conspiring to commit crimes, I think they should be allowed to use RICO for that very purpose. And we're seeing it done more now than we have in the past. But if that's abused, and oftentimes the prosecution team is going to want to bring the RICO for the reasons you just stated, Bob, because you can get more evidence in when you're talking about a conspiracy. You can talk about those phone calls. You can talk about activities that may not even be illegal because it's all part and parcel of that conspiracy, of that RICO claim. So,
right, activities, phone calls, and conspiracies that you may not have had any participation or knowledge was even occurring. I think that is a really great question. As a prosecutor, it certainly is a great tool, but you brought out something, Terri, that I think is really important. I said this as a prosecutor as well. Sometimes they give us more tools and they give us more laws, and you hope that prosecutors will use the rule of reason with regard to how they implement them. But many times I have noticed, even with my own colleagues, that they've gone and taken those laws, not for what they were intended to do, but using them in other environments, which I felt was inappropriate. That is really, really a great question.